Did you know you can spend hours making generative AI music with the most intricate and creative prompts imaginable and legally have no output ownership? To find out if this was true for songwriters and music producers, I went down the intellectual property rabbit hole of the US copyright law and its relevance to the Suno and Udio lawsuits. And what I found is even stranger than you might think, because US copyright registration law isn't confused about generative AI music. It has been rock-solid consistent for hundreds of years. Artificial intelligence was just on top of us so fast, we weren't paying attention. First off, two very fast definitions. An author is the person to whom anything owes its origins, the originator or the creator. Second, copyright. This is the exclusive right of an author to the production of their intellect. But with that out of the way, let's ask a question. Why can't machines own music? At first I thought this might be a new question, but it's not. To understand AI music law, let's look back to the 1900s when the player piano exploded in popularity. These self-playing pianos used paper rolls and no human musician was needed. People loved them and wanted more and more music. So companies started making rolls from existing sheet music without permission or payment. Because at that time, only sheet music could be authorized to hold a copyright registration. So when a sheet music publisher sued, the case went all the way to the Supreme Court. And here was the question that needed to be answered. If a machine plays your music that came from your score, is that copyright infringement? The Supreme Court said no, it was not. The piano rolls were not music. They were mechanical parts of the machine, no different than the piano keys. Luckily, Congress stepped in very quickly, and within a year, the 1909 Copyright Act forced piano roll companies to pay mechanical royalties to composers. Their decision still shapes how we think about machines and music today, because machines don't own music, they execute instructions. This also creates a strange legal limbo. Think of it this way. Most free music lives in a vast graveyard called the public domain. These were works that were born of a human author, lived their copyright lives, and then died after their copyright registration expired. But raw generative AI output, that is a legal ghost. It isn't in the graveyard because it died. It's there because it was never legally born. Without a human author to provide the spark of meaningful human contribution, there is no copyright shield. It is non-copyrightable at inception. But if AI is trained on existing music, isn't that copyright infringement? This debate actually goes back to 1841, when two biographers fought over George Washington's letters. One of the authors copied a large section of the other's massive research. Almost half of his full book was lifted. So he sued and won. But what came out of that ruling was something we still use today. The concept of fair use. Fair use asks 4 questions to the person copying. First, is it transformative, or are you just taking? Second, is the original factual or highly creative? The more creative the work, the stronger the copyright protection. Third, how much was taken, both in quantity and its importance? And the most important question, does it harm the market for the original? What I'm about to tell you is a very hard pill to swallow, but it needs to be talked about when speaking about fair use and AI. Fair use is not something that you get to decide to use ahead of time. Fair use is not a shield. Fair use is not a permission slip. Fair use is a legal defense. You only find out if you have the right to fair use after you have been sued. Only a judge can determine fair use in a courtroom. And I'm sorry, Mr. Beato, you don't get to decide what is fair use. Currently, the big training data lawsuits against companies like Suno and Udio are still playing out. A few have settled into licensing deals, and others still continue. There's no final answer yet on whether generative AI training is fair use. But on the output ownership side, that has become much clearer. Okay, so if AI can't own music, what about the person writing the prompts? Certainly they can own it. You had the idea, You guided it. You did the work. For years, courts recognized something called the sweat of the brow doctrine. If you worked hard, you deserved a copyright registration. In the early 1990s, a company called Rural Telephone published a directory of names and phone numbers. Another company, Feist, asked to use it. Rural Telephone said no. Feist ignored them and used it anyways, and got sued. The Supreme Court was very clear. Effort alone does not protect you. Copyright registration protects creativity, not hard work. Facts cannot be owned. This is the way the Copyright Office sees prompts. They are basically instructions and descriptions, more like facts than creative expression. So according to the law, you cannot have AI output ownership no matter how detailed or iterative your prompting is. There's another useful way to think about generative AI. Photography. When you take a photo, are you authoring something, or are you just pressing a button? Because if it's just pressing a button, then how is that any different from prompting an AI image? Back in the late 1800s, a photographer named Napoleon Cerrone took a portrait of the famous author Oscar Wilde. A lithograph company took that photo, copied it, and started selling it, with no royalties. The company's argument was simple. A photo isn't writing. The Constitution protects authors, and authors use words. Pressing a camera button is not authorship. The Supreme Court enforced copyright protection for Cerrone because he made creative choices. Lighting, composition, poses. It wasn't just pressing a button. But fast forward 100 years, a museum took ultra-precise photos of famous paintings with perfect lighting, perfect angles. When Corel, a company famous for their program Corel Draw, had these photos on a CD and didn't pay royalties, they got sued. The court said that this case had no copyright protection because there was no creativity. They called it slavish copy. Now apply that to AI. When you prompt an AI, are you making a detailed creative choice, like a photographer? Or are you describing what you want and letting the machine fill in the rest? The United States Copyright Office says that AI images are slavish copy, not creative expressions. Here's another extreme example. A monkey grabs a camera and takes a selfie. Who owns the photo? That turned into a complex legal debate, but in the end, no copyright registration. The United States Copyright Office, in their guidance on registration of works containing AI, actually cites the monkey selfie lawsuit case of Nuratu v. Slater as an example of the human authorship requirement. In 2022, artist Chris Castanova created a comic called Siren of the Dawn. She wrote the full story herself and used AI only for images. The U.S. Copyright Office allowed for the registration of the text and the overall arrangement, but not the individual AI images, because they viewed them as derivative works. Even her heavy image edits and enhancements were not enough. They were just sweat of the brow. Then there's the big case that everyone was talking about in early March. Dr. Stephen Thaler tried to register an image created entirely by an AI system. Courts rejected it. The Supreme Court declined even to hear his appeal, once again leaving the human authorship requirement firmly in place. Are you noticing a pattern now? Pure generative AI output, no copyright registration. Heavy human editing or rebuilding, it might qualify, but only the human-contributed expressive elements get copyright registration. So every path with pure AI generation leads to the same uncomfortable place. No clear human author, no reliable ownership. Even AI companies' terms of service cannot magically create copyright where the law says none exists. But here's the good news, and the part musicians need to hear. The law has been consistent the entire time. Copyright protects human expression. Want to know how to protect AI-assisted music? Use generative AI like a sketchpad. Generate ideas, stems, or inspirations. Then rebuild it with a human-in-the-loop workflow by writing your own lyrics, composing your own melodies, performing the instruments yourself, shaping the arrangement, with no AI audio left in the mix. That track is undeniably yours, because that is not a prompt. That is not a copy. It is your work and fully protected. Don't fear AI. Master it as a creative tool. Artists who understand this distinction are the ones who are actually going to own their music in the long run. The law isn't trying to kill technology. It's trying to protect something important, you. So if you want to learn an actual human-in-the-loop AI workflow and use it as a starting point for human-authored tracks, drop a like, subscribe for more real-world breakdowns, and tell me in the comments, would you release a fully AI-generated song knowing it probably had no copyright protection, or would you rebuild everything yourself? Keep making music.